Good evening. Welcome to the City of Kalamazoo's virtual town hall meeting on August 10th of 2020, where we'll be discussing tonight the draft Civil Rights Ordinance and Fair Housing Ordinance, also known as Chapters 18 and 18A. And as this is a town hall format meeting, we are going to have a number of presenters tonight discussing the proposed ordinances. And at the end of the meeting, we'll have an opportunity for the public to ask questions either through email or call in or through the Facebook comment section. We will then present those questions to the panelists and they will answer those questions. You can submit questions tonight through the Facebook comment section. You can also call area code 269-226-6573 and leave us a message and we'll pass that along to them. Or you can email hello@kalamazoocity.org. And we will compile these questions. And any that we don't get to tonight, we will have on the city's webpage for this project, which is at www.kalamazoocity.org/chapter 18. And with that, I'd like to turn it over to Kalamazoo Mayor David Anderson.
Thank you so much, Voice of the City Commission, Deputy City Manager Jeff Chamberlain. And I want to remind people, this is a town hall on two specific ordinances. This is not a regular City Commission meeting. So this is an opportunity for people to listen, hear something about two ordinances that will be coming our way, which will be on our agenda at our next regular City Commission meeting for a first reading. So that is the work we're doing tonight. We have allocated a couple hours, if necessary, to do this work. Our presentation will not take that long, but it gives people an opportunity for some questions. I also do want to remind folks that this is not the first time we've talked about this. There's been many, many opportunities for community discussion. As a matter of fact, just last week on August 4th and August 6th, there were also interactive sessions where people were able to ask about specific things in this ordinance. Still, on the city webpage, the draft ordinance is available, but by the end of this week, on Friday, when our packet is made available for our City Commission meeting, that will be the language of the ordinance that comes to us for action. So that said, tonight we have City Attorney Clyde Robinson here. We have our Director of Community Planning and Economic Development, Rebecca Kick. We have our Director of Diversity, Equity and Inclusion, Dorla Bonner, Vice Mayor, Patrice Griffin, Commissioner, Jack Urban, David Anderson, Mayor of the City of Kalamazoo, and then behind the scenes, making sure everything works great, our Deputy City Manager, Jeff Chamberlain, and our person who helps him with communications there, Neil Conway. So I want to welcome everybody to this gathering, and I'm going to ask Director Kick to take us from here.
Thank you so very much, Mayor Anderson. I'm going to go ahead and share my screen so that we can get started with the presentation. Like mentioned, it's going to take about 20 minutes, maybe 25 tops, and then we're going to get into questions and answers. Here's just a reminder about how you can submit a question and a comment tonight. You can comment by leaving a question in the live stream. You can call the phone number that Deputy City Manager Chamberlain left for you, which will be back on the screen later. And you can also send an email to hello@kalamazoocity.org. These are all the participants in the panel tonight, and then City Attorney Robinson, Director Bonner, and myself will be the ones mainly giving the presentation, with Vice Mayor Griffin as well, talking about partnerships. So this is the agenda tonight. We're going to first talk about the changes to the ordinance. If you have participated in past sessions about this, as far back as February, this was one document. And so Attorney Robinson is really going to walk you through how this became two documents. I'm going to walk through a few of the overview and additions and changes that happened to the ordinance as it was broken into two parts. Director Bonner is going to talk about the Civil Rights Board and the role of the DEI, the Diversity, Equity, and Inclusion Office. Vice Mayor Griffin is going to talk about partnerships and the importance and their importance in this ordinance. And then lastly, Mayor Anderson is going to discuss the future programs and studies, which also may they're not directly related to the ordinance, but also affect housing. So first, I'm going to turn it over to Attorney Robinson to discuss the changes to the organization of the document.
Thank you, Rebecca. As you indicated, we had one large ordinance, one chapter, Chapter 18, which we already have in place. But what we wanted to do is add additional areas of protected classes. And as we were moving through this, and I'll say this, we had, as Rebecca indicated, a lot of feedback. We had just shortly before the COVID lockdown really took place, there were a couple of listening sessions. We also encouraged people to send us their comments by email and the like, and those comments were reviewed. And while some of them, not every one of them led to changes, they did highlight some concerns that were brought to our attention. And in going through those concerns and seeing how, I don't want to say unwieldy, but how large the ordinance became, it was suggested that maybe we ought to break this into two, that we have a general ordinance that addresses discrimination in general, and then we also have a subchapter or a separate chapter that actually highlights the issues regarding housing discrimination. And so that's the course that we took. Fortunately for us, we found that two other communities used a similar approach. And to that end, in going through our ordinances and seeing what was best practices, I found that Grand Rapids and Ann Arbor were particularly helpful. And that is a good, not only were the ordinances similar, much of the language was the same, the organization, the way we want to approach the issues were handled much the same way in terms of the goals and the process that those two communities used. The other nice thing about these two communities is they are larger communities in Michigan. They are communities of a diverse population. They also have significant student populations. So for those reasons, it was seemed that those two communities were a good match for us to follow. To that end, what I did was I broke into a separate chapter housing issues for ease for everybody's use, for staff, for landlords, for potential tenants, so that you can locate immediately in one place the fact that here are the ordinances that address housing discrimination. There is still Chapter 18, which is a general a chapter that talks about discrimination in general. That's where the Civil Rights Board material is found. That's where many of the definitions are found. The other thing that's important to know is that the two ordinances are tied. When these go before the City Commission for consideration and adoption, they will be tie barred. In order for either one to be effective, they both have to be adopted. So that is the process going forward. Some of the things that were changed is the fact that what we did not want to do, and again, neither one of these other two communities do it as well, is that we did not want to duplicate those processes that already exist either at state or federal law. So while our ordinances clearly define those types of discrimination, if that type of complaint comes to the city, it will be reviewed. And if it is something that is better handled at the state or federal level, because there are already laws at those levels that would cover it, those complaints would be forwarded on to those other agencies. It is only those types of things that are uniquely identified within our local ordinance that the city of Kalamazoo would investigate and process. The other change that was significant, and this occurred very late in the process, and this may be for those folks who went through the change. The last time this chapter was addressed was back in 2010, is when we expanded it, the protections in our ordinance to protect sexual orientation and sexual preference. And to that end, given what the U.S. Supreme Court decided in June of this year, that is now considered a form of sex discrimination. So therefore, while that protection still exists, it's not explicitly called out, but it is identified consistent with the U.S. Supreme Court's decision as a form of sexual discrimination. So it's still covered in the ordinance, it's just covered a little bit differently due to the change in constitutional law.
Next, I'm going to go over a few of the additions and changes. But first, because there are some storm warnings out right now, I just wanted to be able to mention that if for any reason anyone has technical difficulties, or even if we have technical difficulties, we've tried to make several people the host of this meeting. So we're all located in different parts of the city. So just in case any one of us drops off, another one of us can kind of pick up where we're at. Hopefully we won't have any technical difficulties tonight, but I did want to mention we are expecting quite a storm tonight. So I hope everyone stays safe. So I want to go back to this slide, and this is one of the first slides that Vice Mayor Griffin had been presenting with the TRHT and Isaac groups. And what's really important about this slide is that the fundamental foundation of these ordinances was really built on these protections, and they are still all there. And so while the ordinance has been split into two pieces, and while it has gone through other clarifications and changes, the foundation of the ordinance stays the same. And as Clyde had mentioned, the new court ruling on June 15th, where the court says that this language of the Civil Rights Act prohibits sex discrimination. Again, this applies to sexual orientation and gender identity in a new way in this ordinance, and now it is lifted above just our local status. So when Director Bonner and I took this ordinance, and we had big plans to lead a big public participation effort in the beginning of March. We held the commission work session on February 24th, seems ages ago, and then we were quickly sent home with all of the coronavirus executive orders. But what we were able to do was hold a couple of roundtables from our office, as well as get feedback from listening sessions, lots of emails that we received, phone calls, and lots of Zoom interviews that led to the separation of the document, which we feel gave clarity to the document and to the process to assist with implementation. There were things that were expanded, which came out of Ann Arbor and the Grand ordinances, which then include the sale, exchange, rental, or lease of real property. Including the sale and exchange of property is also an important part of the housing ecosystem. Clarifying language was many times a lot of the questions that we got. Could you please clarify, what does it mean to have a blanket policy around evictions, or a blanket policy around arrests and convictions? And also we worked to clarify that language, again, by using some of the sister ordinances. We also clarified language in arrest and conviction statements. It is not lawful to use arrest records, and it's very clear in our ordinance how conviction statements can be used. We did include the ability to pay utilities in income qualifications. We realized that many property owners do not necessarily include utility payments in their rental fees. And so it was important that when checking income qualifications, that the ability to pay utilities could also be considered. Lastly, the original ordinance had a 180-day reporting time frame, and we have changed that to a 91-day time frame. And then after that reporting period, Director Bonner will walk us through what does it look like to lodge a complaint and how long would it take for that to come through the office as well. So I'm going to go ahead and turn this next part of the presentation over to Director Bonner.
Thank you, Director Kick. And I want to apologize in advance if my voice goes in and out. I'm fine. I'm not crying or upset. I just have an interesting voice. So I'm going to spend a few minutes talking about the Civil Rights Board, the purpose, our capacity in the diversity, equity, inclusion, and the partnerships that we have with the state to get this work done. Okay, next slide. The Civil Rights Board is only going to hear cases that apply under our local protected classes. But we will hear all discrimination cases. To that end, all of the discrimination classes under Chapter 18. The board will make recommendations to the city manager. They will be trained through fair housing law. And it is important to us and to our community that they reflect and represent the diversity of our community. Okay, next slide. Just a little bit about the Diversity, Equity, and Inclusion Department, a brand new department created in February 2020. It is myself and I have one part-time staff, and we have the opportunity to have new staff as need arises. Right now, our partnership with the state, the reason we don't have to do those for federally and state protected classes is because we have our own fair housing center within the city of Kalamazoo. And we're also, we'll be referring cases to complaints rather to the Michigan Department of Civil Rights. We're going to make sure that we do not duplicate services that the community and our state already have in hand. The complaint process. Once a person files a complaint with the city manager, our city attorney along with the city manager will review the complaint just to see if which level it falls into. If it is a federally or state protected class, they will either be referred to the state Michigan Department of Civil Rights or our local Fair Housing Center of Southwest Michigan. If the complaint is local, the city manager will assign an internal investigation within the city department. The Civil Rights Board will receive the results of that investigation, and they will make their recommendation to the city manager. If that person and those folks don't agree with that, the appeals can come back to the board for reconsideration, or the case may come to the city manager or designate for conciliation. One question that was asked before by a landlord is, when would that case be made public to the landlord? If the case is valid and we have to investigate, it would be made public at that point. But if there is no case, we won't, there's no use to going further if there's no need to. I think that's my section. Yeah. Great, thank you.
Thanks, Director Bonner. I'm going to have the Vice Mayor Griffin take this slide.
Thank you, Director Kick, Director Bonner, and Attorney Robinson. So yes, partnerships and ordinance. And as the slide says, partnerships are critical to our housing stability. This ordinance is a prime example of how partnerships are important to that process. This ordinance was started with community, understanding all of the different the gaps in our housing community here. Myself working with many other organizations and many people, such as Dr. Charlotte Davis with Isaac and Shawana Lulis with Truth, Racial Healing and Transformation out of the Kalamazoo Community Foundation. So just to briefly touch on, there were a lot of engagements done prior to this point, speaking with people who needed help with housing, people who provide housing, and everyone in between on that spectrum. And so, many people know this, some people are not aware of this, that the city does not directly provide housing in the sense that The city doesn't own any properties. What the city does is support housing with federal funds, ordinances, and other forms of support. So by having an ordinance like this, the city of Kalamazoo is providing a framework for equitable housing in this city by saying, you know, discrimination, we need to minimize that in order for us to have a more healthy housing flow for everyone in this city. We're part of an ecosystem of housing that includes all of the people that I just named. And so in order to make this a successful ordinance, there's still going to need to be communication, building relationships, education for all parties who play a part in this housing ecosystem. And in order to really make sure that we have a full understanding, it's going to be very important. And there's been different times along the way and moving forward that we really understand our past and the different factors that played into why our community it looks the way it is, why our housing has been the way it is, and how important this ordinance and other things will be to improve our housing community and really achieve housing equity. Thank you.
Thank you so much, Vice. So, recap the community conversations that we have had for the new draft ordinance. Like the Mayor Anderson had stated, August 4th and August 6th, we held 2 different landlord forums. On August tonight, we're holding the town hall for all of you to participate with us. And on August 13th, we're going to hold our last forum with housing support partners in the afternoon. And then we are going to be looking at bringing this to the City Commission. So Monday, August 17th, Attorney Robinson, Director Bonner, and myself we will be giving our last presentation. We're going to keep it super short, and we'll just be talking about things that ultimately have changed based on this feedback. And then we're going to talk about what's next. What happens when this is adopted? We've heard a little bit about the Civil Rights Board. We will need to recruit for that board, including training on fair housing law for the board, as Director Bonner had mentioned. Setting up additional staff if necessary and procedures for implementation, as well as allowing time for landlords and tenants to prepare. So at this time, while we don't know exactly when that would take place, like after the public hearing on September the 8th, most ordinances go into effect after 10 days. We really need to consider that 10-day window. Would we be ready to hear a case on day 11? And so we do need to reflect internally just to be sure that we know exactly when we would be able to begin hearing those cases. So lastly, we're going to talk about, again, after this is adopted, what are some future programs and studies that staff internally have been considering? And I'm going to have Mayor Anderson talk about some of those directions. David, I think you're muted still. Sorry about that.
Thank you. Turning it off so the thunder would not be coming through my microphone.
Yes.
So, yes, so thank you, Director Kick. I appreciate that very much. I just want to remind people that this is the normal process that is followed. Actually, I would say this is probably in excess of the normal process that's followed in terms of providing an opportunity for discussion and evaluation of an ordinance that we vote on at the city. But it is normal that every ordinance, this is standard practice, comes to us for a first reading and then will come back to us for a vote. So that's the 2 dates that Director Kick was talking about. There's also a fact that at the point that this ordinance comes to us for what is called the first reading, we are pretty confident that that reflects the ordinance that is going to go to us for the vote, that there won't be substantive changes between the first reading and the vote. If that were the case, we would have to extend that process. So now is the time. If you have any particular input you want to provide, I mean, the time is coming to the end here. So Just one little quick thing here before I get to this. Director Kick, at this point, how would somebody go to see the draft ordinance at this moment if they wanted to?
They can go to this website that's on the screen right now, which is the kalamazooCity.org/chapter 18. And not only can you see the draft ordinance there, but even the presentation that was done in February with Vice Mayor Griffin, Dr. Charlie Davis, and Shalana Lewis from Truth and Racial Healing and Transformation. Their presentation is there as well. So you can really get the why of the ordinance, the data. You can look at the draft ordinances and see the whole progression. Even our July 20th presentation is there, which is nearly the same as the presentation we gave tonight, if you weren't able to see that as well.
Very helpful, Director Kick. I appreciate that. So what is going to happen as we go forward with this? We are working on some other initiatives, which are parallel initiatives. One of them is a pilot related to security deposit assistance. So all the pieces of that haven't been worked out yet, but we've been doing a lot of work beginning to imagine what that could look like. Another thing is putting together a committee to review our rental registration process. I'm sure anyone who is currently in the landlord business knows that the city of Kalamazoo is actually the only jurisdiction in the county that requires not only a registration of a rental unit, but certification of that unit with some timeframes related to that. So we already have a rental registration process. There's going to be a committee that will review that. In addition, this is the kind of time when you want to do training. So we'll be training on fair housing law. I think that's training that needs to be available for landlords, but for tenants as well. And since this is a brand new ordinance, for us here in Kalamazoo, we intend to have a review. What does this look like? What has occurred some year and a half into once this passes? Director Kick, anything else?
No, thank you so much, Mayor Anderson. I think lastly, I just want to be able to say that before we start our questions to the panel, that if for some reason we're not able to get to everyone's question tonight, they will be shared online. Again, at our website, kalamazooCity.org/chapter 18. We're going to be compiling very much frequently asked questions and then answers by staff. So that will be available in the next couple of days. As a last slide, I just wanted to be able to remind everyone how they can participate tonight. You can comment in the live section. You can give us a call at the phone number 269-226-6573 and leave us a message, or you can email hello@kalamazooCity.org. I'm going to stop sharing my screen now, but that phone number will still be available for you to call. And I'll go ahead and ask Deputy City Manager Jeff Chamberlain to help us out with the first few questions.
Sure, we do have a number of questions, some ranging from policy questions to others ranging to specifics about the ordinance itself. So just to get it started off here, there's a phrase used in the ordinance that says, quote unquote, blanket policy. Can you explain that?
Would you like to go ahead and take that, Attorney Robinson?
Sure. Blanket policy is where you don't have the use of discretion, or you're not assessing the circumstances before you. A good example is, I'm not going to rent to anybody who has had a felony in the last 10 years. Well, there's a variety of types of felonies. 10 years is a long time. And so what we're asking you to do is, yes, if somebody had some type of felony of violence, maybe in the last 2 or 3 years, that might be important. But for somebody who had, for instance, driving away a motor vehicle, and it was 10 years ago, while it's a felony, it's not that serious, and you would not necessarily expect that person to be a rental risk in today. So that's what we're looking at is that you make an individual assessment when you're looking at people's backgrounds and credentials.
Okay. Does this ordinance require housing providers and landlords to accept vouchers?
Would you like to take that question, Attorney Robinson? I could maybe start it.
I don't know that it
want me to.
requires that you just can't discriminate on the fact that the person is using a voucher.
Correct. It's more about the source of income is what is protected. And so if a potential renter can show you that their income can indeed pay the rent, it's about discrimination of the source of the income.
Well, and related to that, are we removing any income threshold requirements as a result of this ordinance?
No, we would not be. For example, the standard affordable income requirement being 30% of what your annual gross income is something that the state uses, the federal government uses. We would not be removing any of those standards.
And regarding the Civil Rights Board, what type of cases will they be hearing?
Well, they won't necessarily be hearing cases per se, because what will occur is if there's a alleged violation of our ordinance, and it appears that there is reason for further investigation after the complaint is initially reviewed, then it'll be investigated by an appropriate city department. It could be investigated by somebody from public safety. It could be investigated by somebody from community planning and economic development, or maybe even HR, people who have gotten within the city some experience in doing types of investigations, which we would call people in, ask them what happened, find out some other information, and then after that investigation is done, a report would be made. It would be submitted to the Civil Rights Board for its review, and so it can make a recommendation to the city manager as to how the matter should be dealt with going forward, which could be arranged from a variety of things. It could be maybe a conciliation between the complainant and the landlord. It could mean prosecution. If this is not the first type of complaint that's been lodged against the landlord, we might look at prosecution. But if it is, if it's just maybe a question of communication, maybe that can be conciliated, and that there is no necessarily punitive action taken by the city other than trying to make everybody make the complainant whole.
Related to that, if there is a charge against a landlord and the city does begin an investigation, what type of due process rights does the landlord have?
They will have the usual due process that is available under the common law and the constitutional law. They'll have a right to have representation. They'll have a right to confront witnesses against them if we have a formal hearing. They'll have an opportunity to be informed of what the nature of the charges are, and hopefully they will cooperate with the investigation. If they don't, then the records can be subpoenaed. But yes, they will get the usual due process rights that are required under law.
And also related to that, will the court system have any involvement in applying or adjudicating cases related to this ordinance?
Only if there's a determination that the matter should be prosecuted as an ordinance violation, then that would go to the 8th District Court. Hopefully those would only be the extreme cases.
So, slightly different topic. This individual says that the vacancy rate in Kalamazoo apartments is very low right now. How will this ordinance help get more people into housing in Kalamazoo, or will it?
Vice Mayor Griffin, would you like to talk to that question with the research and the data that you helped to prepare?
Sure, and that's a really great question. So this ordinance, as you know, we've discussed anti-discrimination. It really deals in the barriers that people are experiencing when they're trying to get into housing. So background with their eviction history, how they pay their rent, and any sort of criminal background. These are the barriers that people are experiencing. So you can have, you know, units built and have units available, and people still won't be able to access them. So this is really about an access issue for people. And so making sure that as we look to create more housing and look at this, the scope of the landscape of our current housing availability, that people have access to those and actually have housing choice.
Okay.
Thank you.
If this ordinance is passed, how will the city monitor landlords?
I don't know that we're going to monitor landlords per se. Obviously, we monitor landlords to some degree now with registration of rental properties. So that doesn't change. What we are going to be responding to are complaints that come to the city. And that's no different than what we've already have in place with our current civil rights ordinance, that if somebody comes forward with a complaint of a civil rights violation, then the city, again, reviews it. And if we feel that there is sufficient grounds to believe that investigation be undertaken, we will do so.
Okay. Can somebody talk a little bit regarding the compliance that's required under the new ordinance as it pertains to application fees and advertising and record keeping?
The ordinance as it states right now, and Attorney Robinson, you could talk about this, and maybe Director Bonner, if your office is going to have any part of this, is that we have a requirement that the tenants that you have know that this ordinance exists and know that they have rights within this ordinance. How that's posted in your office, or how that is displayed on a website or on an application, I believe we still need to work those details out. And in the ordinance as it stands right now, we are asking landlords to retain 1 year of records.
Okay.
So Director Kick, just to follow up on that, and I'm not sure if there's total clarity on that, but Deputy City Manager Chamberlain, you were talking about, are there specific effects on fees for application, correct?
Correct.
And a couple other issues there. What were those again?
Application fees, advertising, and records.
Well, in regard to the application fees, you may not charge, a landlord may not charge something that exceeds the actual cost of obtaining the background check process. So that you can't charge add an administrative fee on top of the actual cost of acquiring the various reports that you're looking for. And you have to provide the potential renter an itemized list of what those costs were, so as to basically verify that you're not charging more than you're permitted to. In terms of advertising, then you may only advertise those properties that are available for rent and occupancy unless the applicant otherwise consents to be added to a waiting list. So those are basically what we're looking for, so that there is you can't, if you will, tell somebody, well, everything's taken and I'll put you on a waiting list, and then use that as a form of discrimination. So if somebody comes in who you think is a better risk, even though they come in late, you've already kind of promised it to somebody else, that you're not permitting people to jump in ahead of the line, so to speak.
And as far as from the Diversity, Equity, Inclusion Office and the Civil Rights Board, with the training that we're going to try to make sure everybody has before this ordinance goes into effect and compliance is expected, these are areas that a tenant can file a complaint on if those things don't occur. So that's the connection with us. I think that's what you asked me, Director Quick. The connection is that once they understand their rights under the ordinance, then they have a right to file a complaint, and then it will fall under the Civil Rights Board and the investigating body within the city.
Okay. Well, kind of related again to the Civil Rights Board, are there rules or bylaws for that board?
Those will be formed after the board forms. Ms. Bonner and I had a discussion earlier today. They will likely track similar bylaws that already exist for other boards that are used by the city, such as CSPRAB, the Citizens Police Public Safety and Review Appeal Board, the Zoning Board of Appeals, and the Planning Commission. All of these other boards have bylaws that direct the way they go about their work. And I would very much envision that the Civil Rights Board will have similar types of bylaws.
Attorney Robinson, we appoint members of those boards. Will the City Commission then be involved in appointing members of this board?
Yes.
Okay. So on a slightly different topic, if a tenant causes damage to a unit, is the city considering any kind of landlord insurance program as part of this?
So last year, Vice Mayor Griffin had provided city staff with recommendations for a landlord resident connection pilot that was based on some existing programs operating in other parts of the country. City staff has shared this information with United Way, the Continuum of Care, and the Upjohn Institute staff. And Upjohn researchers have assisted us with looking at several housing partners to develop a proposal for a security deposit and added insurance program proposal that will help people overcome the barriers of those screening requirements and even high moving costs. So the pilot is still very, very much under development. We look forward to sharing more of those details within this next month, but know that this is something that we are certainly pursuing.
Okay. A couple more questions about the Civil Rights Board. Will there be landlords on that board?
There could be.
At this point, there are not designated seats on that board, though, correct?
That is correct.
There's a provision in the ordinance for religious exemption under section 18A-8. Could somebody explain how the Kalamazoo Gospel Mission and the work they do, and if the work that the Gospel Mission does it meet the needs, and they meet the needs of the homeless population? Could you please talk about the intention of this exemption for shelters and how the exemption works?
Well, I don't want to talk about any specific organization, but I can say that the ordinance is drafted so that if a religious organization has housing that is reserved for people who ascribe to the tenets of that particular faith, that's okay. However, if they also have a program that is open to the public, you don't have to necessarily be a believer or a member of that particular faith, then those facilities have to be open to people generally. You can't discriminate on any of the protected statuses in the ordinance. So again, if you're open publicly, yeah, you have to permit people of all stripes in order to use your facilities. But if you have some facilities that are reserved for adherence to your particular beliefs, then that's okay.
Thank you, Attorney Robinson. I just wanted to chime in just on that question briefly. As we were working through this and specifically having the ACLU take a look at our ordinance in existence, that particular piece is something that jumped out. So that language change is just adjusting the language to practice that had already been in place. So it wasn't about a specific organization. It was about an overview and looking at our ordinance, and that particular piece needed to be updated to what was supposed to be happening currently.
Can you recap again why this ordinance is needed?
Oh, sure. Well, for many of you who have been following this journey for quite some time, housing in the city of Kalamazoo currently as it stands is not equitable. And this is a necessary step to take it in that direction. And so just to give a brief overview, and I'll just give county, I'll give county numbers because I'm trying to paint a whole picture here. The city of Kalamazoo, or excuse me, the county of Kalamazoo is roughly 11% Black, yet 60% of the people that are in housing crisis are Black. And so when you peel back those layers and you look at that data, it all points at discrimination. It's not about socioeconomics. You have a lot of people who have the income who are living in hotels right now. And so inequitable housing destroys a community across the board, and it just disproportionately impacts some groups more than others. And so when you look at a climate of housing, and where the city in particular is trying to do a lot in terms of development and things like that, you have to ask yourself, if we create all of these units, will people be able to access them? And without these updates to our housing ordinance, we will not see that. And so other communities, as it's been lifted up, have already adopted these ordinances. Communities in the state of Michigan, communities across the country who have already seen that, you know, a lot of the reasons why our climate of housing looks the way it does is because of discriminatory housing practices, historically redlining and so on and so forth. And even though those practices are illegal, the effects are still the same. And so people have trouble. We have a millage program here that a lot of people voted on, Vote Yes for Kids. We have the housing choice vouchers. And with those, in spite of having those two programs, there are families every day that are not able to get into housing because currently as it stands, you do not have to even consider a person just because they have a voucher. And so that leaves a disproportionate amount of families in a crisis situation. Same thing with evictions and with criminal backgrounds. We have many people who have, you know, their past, they have done things, whatever, and they're moving forward and they're living in hotels because they're not able to get into homes. We've got application fees. People are paying hundreds of dollars a week, not knowing if they've been approved or not. So all of these various factors that people have been going through for a very long time, this ordinance is looking to address them. Now, it doesn't fix everything. There are many things that still need to be addressed, but this is a step in the right direction to be followed by more.
Thank you. For landlords, will this ordinance create additional costs or financial burdens for them?
I'll try and start with that one. There are no fees that are directly related to the ordinance. That wouldn't, there's more that's kind of to our rental registration program. Being a landlord does cost something in the city of Kalamazoo because of our rental registration program, but this ordinance does not charge anything to a landlord just off the top. There are fines that are related to some of the charges in the ordinance, but there are no other financial penalties.
So again,
Add a little bit to that.
Mhm.
I certainly, you could suggest that there are some record keeping requirements or some other things that
Mhm.
come along with this. But I would suggest that most people who are, professionals involved in the business of managing or owning and managing property already have processes where they keep those appropriate documents. And, in addition, landlords are very used to having to comply with the Fair Housing Act, which has been around for a long, long time now. So this does not really change the landscape of that to any significant degree.
okay. So again, related to landlords, if somebody makes an accusation and it turns out to be false, and the landlord has incurred costs through this process, is there a restitution or some other way for that landlord to recoup those costs incurred during the process?
Not directly, and I don't know what costs would necessarily be incurred other than perhaps obtaining legal representation, but that's something that each person has to consider on their own as to whether they wish to do that.
Okay. Part of the requirement of the ordinance also talks about past tenant files. So does an audit require that we, the landlords, expose past, current, and future tenant application files? And if so, does the owner of that information have any right to privacy or authorization to disclose?
The only information that would probably not be subject to disclosure would be credit history. I know that there's a Fair Credit Act that has to be observed when somebody comes in contact with that information. But I would imagine most of the other information the city would already have access to anyway, for instance, criminal histories. That if it's generally available to a landlord, it would be generally available to anybody else. So, and the only reason we would be, there's no audit, so to speak. It's just if we get a complaint that there's a discrimination claim, we hear from repeated people that they are being discriminated against in a particular way by a particular landlord, we would probably want some proof that there's not a pattern of behavior here that we would look at. But there is no general audit, and we'd only be looking at records that would be relevant to either the nature of the claim or a pattern that we discover.
Okay. So we had a couple more questions about housing affordability and how this ordinance will either help or not make any difference as it goes to affordable housing inventory in the city of Kalamazoo. And also, does this ordinance open up any more low-income housing for people who perhaps could afford the housing, but they cannot get into that housing because of something in their past, such as a felony or something like that in their history?
I think I'll leave others to answer, but that is one of the goals of this ordinance. So is to remove barriers for people who can't seem to get housing now, and there's nothing really that would preclude them other than something that's in their past that is perhaps in their distant past, that's really no longer relevant to the way they conduct themselves.
Okay.
And do you think that Director Kick, is there something you want to add on that question?
No, I think that Attorney Robinson has answered it really well in saying that, again, this is about removing barriers of discrimination. And when people that Patrice and Charlotte and Shalana, Director Bonner has had so many of these conversations throughout her career as well. It's just that when we talked about the blanket policy, again, if you've always had this blanket policy of saying X when Y, you know, you've had one eviction or you've had something like that, like, we're not going to talk to you. We wouldn't look at your application. That's what this is about. This is about having a conversation with someone as opposed to just dismissing them off the bat.
The data that's been talked about to support the claims about how this will improve the housing process here in Kalamazoo, is that data available to anybody? And where would they go to find that?
Director Bonner, do you want to talk about the HUD data that we use and talk about within the analysis to impediments?
Well, so a lot of the data that's been referred to was based on a report that we've been working on for HUD, which is called, for Housing and Urban Development, which is called the Analysis to Impediments to Fair Housing. But the reality is that this ordinance was, and this is why I think Vice Mayor Griffin can answer better. This ordinance was started before we collected that data. So, and you would have to, she brought that to us via an Isaac issues conference, I believe it was, a couple years ago. And some of the information that we've received from the engagement through the analysis to impediments what supports the ordinance. But the order of the flow was that she presented the ordinance and then we did the engagement. So I'll let her talk about where she got her support for the ordinance.
And just to clarify, because I didn't hear what DCM Chamberlain said, just why an ordinance is needed, or?
Well, there's been some references to data, and the question was generally, where can somebody find that data?
Oh, okay, yeah. So Director Bonner answered that perfectly. Throughout this engagement process, and I'm just going to reiterate what she said, you know, I started down this process before finding out that the GEAR work was happening. It just so happened to be at the same time as presenting this, they were doing engagements. And so it was no shock to me that the data came back and supported, you know, what had already been presented, because this is an issue that's happened. It's not specific to Kalamazoo. We just hadn't, you know, addressed it in this way yet. So, you know, Grand Rapids has adopted this ordinance. I guess we're probably about a year out now. And so it's just important for people to understand that not discriminating is not going to destroy your business. If you've been discriminating, then we probably have other issues that need to be addressed. But this ordinance is just about removing the barrier of discrimination that is causing, you know, a lot of trouble with people locating housing. And again, this is not fixing everything. This is just a step.
Okay, thank you. Mayor, I'm sorry.
I was just going to say, Vice Mayor, you used a shortened form of a acronym, the GEAR work you talked about. Do you want to just expand
Yes,
on
I'm
that?
sorry. Yes, thank you. GEAR stands for the Government Alliance for Race and Equity. The city of Kalamazoo was one of 3 municipalities in the entire country to receive this grant to do intentional work, as Director Bonner has listed before. And actually, the city was recognized last year for doing this work. And there have been many organizations who have taken a look at the work that has gone into it, because very rarely do municipalities partner with civil rights organizations. And I'm sorry, I guess I should take that back. In that GEAR partnership is the City of Kalamazoo, the Michigan Department of Civil Rights, Isaac, the Kalamazoo Community Foundation, and the Fair Housing Center of Southwest Michigan. So that collective of data was used.
So was part of that work collecting data sets?
Yes.
And are those data sets available to people in any way, or could they be made available?
So throughout this Throughout this process and in many of the presentations, including the one that we gave in February or March, we used some of those data points and presented those out. That actual entire report is in its final editing stages and it's going to be made available publicly. I'm sorry that I don't have a specific date for you this evening, but it's in the final editing stages. It was a huge undertaking that had never been done before. And so it was just really important that the work be able to be received by community and not a heavy report that would be difficult to digest.
And I
Thank you, Vice President.
want to add to that report is just not the city's report. There are a couple of agencies working on this report. So when somebody comes to the city, they won't get that entire report yet. So just to know that when you have a collaboration, there's more than one group putting out the final document. The city has the report that focuses mostly on the publicly available data through the census data, through the American Community Surveys, through the Housing Mortgage Disclosure Act. So just know that it's coming out together, but we're not doing them. We're doing them together, separately together at the same time. That makes sense.
So, not to get too deep into this here, but just to apprise some additional clarity, I guess. One of the things that a community does and was being required under the HUD, as far as affirmatively furthering fair housing, Director Bonner, is that you look at community impact in more of a macro sense, right? And then you interpret the fact that it would seem to point to certain actions based on what outcomes look like. Is that an inaccurate description of how that would be evaluated? So that there might not, in every case, be a level of micro data that hasn't been being collected in a certain way, although Fair Housing Center could have access to some of those things. But just that idea of how that, when you look at an outcome and then attempting to measure some of the things that might be contributing to that outcome.
That is correct. That's correct. The report requires us to determine, to analyze the impediments or the things that keep people from obtaining fair, safe, and affordable housing. And that goes across the board at a higher level. Everything from wages, poverty levels, zoning issues, the whole thing. And it also requires us to determine actions that will impact those impediments.
Last thing, I'm going to stay on this, I guess, just once again, not to drag it on too long, but in 18 months or by that time frame, we're talking about doing some evaluation on this ordinance, correct? And I would assume that during that time, we'll obviously have more very particular data that will be collected as well.
Yes. And that's something that Director Bonner and I are working on also, again, with our partners in Grand Rapids, asking about, what kind of metrics are they looking at? What kind of lessons learned have they had when their ordinance went into effect last year? And so really trying to learn from others as we look forward and thinking about what is it that we should be looking for.
The next question is a little bit related to kind of the federal government and some of the information we were just talking about. Will this ordinance affect any of the federally funded rental properties that are already in the city of Kalamazoo? And secondly, will this ordinance supersede any of the current resident selection criteria that those properties and landlords already have in place now?
Do you want to answer that question, Attorney Robinson?
I would think that if you're following federal guidelines, then there would be no problem.
So in effect, the ordinance most likely would not be in conflict with anything that the federal guidelines would have.
True, the ordinance tracks general federal and state discrimination law. What we've done is add a few more protected classifications, and this is, I think, really important, and this builds on what Vice Mayor Griffin and Director Kick have already said, that there is a history of discrimination that we're still feeling the effects of, and there's continued discrimination. And so to the degree that this ordinance is going to assist in eradicating that or reverse that trend, that is consistent with what federal and state law already do. So if there are efforts that are being made that are, and you're following existing federal and state guidelines, that should not be a problem under our ordinance. We are not crafting an ordinance that runs afoul of existing discrimination law.
So
Just
next
to add a
question.
little more clarity to that, I'm sorry. In some cases, for housing that has received federal assistance, there are more than guidelines. There are very specific operating rules which you must follow and don't have a choice about. So obviously, a city ordinance cannot override certain operational practices that come along with a certain kind of funding program, for example, that has occurred. So there's no way a local ordinance could override specific things like that.
Right, that would be ostensibly a defense, if you will.
Next question is related to the size of properties. Does this ordinance apply to all types of properties and landlords, or is there a size criteria as far as it only kicks in when there's a certain number of units, or it only kicks in when a landlord owns a certain number of properties? Or does it apply to all landlords regardless of the number of properties?
It's the latter. The only exceptions are if you are leasing a space within your home, or you are leasing a duplex and you live in one half of it.
Yeah, an owner occupied unit.
Okay.
Another exception is if a group of people, and again, looking at students primarily, but it doesn't have to be, they say the four of us are going to rent a unit. If those four people say, well, there's somebody who we don't want to be part of our unit, I mean, that's okay, because you are, as a group, you are leasing a particular dwelling unit for the four of you. Just because there's somebody else who wants to be part of your group, you don't have to accept them.
Okay, the next question refers to the fact that it appears that this ordinance addresses only issues on the landlord side and does not do anything to address any issues related to tenants or issues that landlords have with tenants. And in this person's view, that it's sometimes the tenants causing problems that cause a shortage of rentals in the city of Kalamazoo. Is there anything that applies to the tenant side of the equation as it pertains to this ordinance?
This ordinance is aimed at discrimination. If there are other issues that landlords have with the tenants, there are other avenues for redress. It's very unlikely that a tenant is going to be guilty of discrimination, and that's what this ordinance is aimed at.
Okay. Going back to,
As an aside, I'm sorry to interrupt again, Deputy City Manager, but we did talk during the presentation about a parallel program related to security deposit assistance and or some form of that, possibly in an insurance program that could assist landlords with things like damages in those areas. That's not part of this work, but that is work that is progress is being made on putting programs together along those lines. So more to come on that.
okay. So going back to the Civil Rights Board again, when they hear a case, what are the possible outcomes And where would a case go after the Civil Rights Board?
Well, the Civil Rights Board is going to receive the investigation and make a recommendation to the city manager. It's not necessarily going to be a hearing, if you will, so much as they're going to evaluate the report and make a recommendation to the city manager. Now, the individual who who's being accused will have the opportunity to have some input into that decision-making process, but that's really what we're looking for, is for that board to weigh in, vet the investigation, so it can do a variety of things. It can say, we don't think there's enough here. We think you should go back and investigate some more. They can say, we don't agree with the way you've come to the conclusion. We come to an opposite conclusion, and we're going to make that recommendation to the city manager. Or they can also say that we don't agree with the recommendation that you've provided to us, and we want to make a different one. So there's a certain limit to what they're going to be able to do, but there's also a certain amount of discretion that the board can exercise when they are evaluating the investigations that are provided to them as to what should be the next steps.
Another question regarding tenants and landlords. Are there any incentives being thought about for training for landlords and tenants to help them be successful and to help make this ordinance successful?
Yes. Actually, Director Bonner and I are both in conversations right now, planning some trainings with the Fair Housing Center. We spoke about the trainings that would be necessary to set up the Civil Rights Board, but we're also looking at a series of trainings for landlords, first and foremost, to understand fair housing law as it exists. So this isn't not even our ordinance, but fair housing laws that are on the books right now, based on much of the engagement that we've done, are very misunderstood. And so both tenants and landlords can have the chance to have a great refresher on what the fair housing laws are currently, as well as tenant rights. And then we can talk about also the additional protected classes and discrimination that is within our ordinance. And we've just started discussions about what would that training look like, who could we hire, who could facilitate that training also.
But Rebecca, I almost called you Dr. Kick. The question
I'll
was,
take it.
the question was about incentives. We have not discussed any incentives for those trainings, right? I think that's what.
Correct. Oh, yes, correct. We're not, right. Like, what's an incentive for the training?
Right.
I understand. Right. We haven't said that the security deposit or landlord insurance assistance is based on training. We haven't really connected those two things, which we very well likely could, if that is what you could mean by an incentive. In order to take part in that landlord insurance or security deposit assistance program, then participate in the trainings that we are offering. That could be a likely outcome that we could discuss with the commissioners.
Okay. Will this new ordinance have any effect on rent price, quote unquote, price gouging?
I don't know that it will. I mean, we're going to obviously, does have an effect on the fees for doing background checks. But in terms of attempting to regulate the market, it does not.
And then going back again to the Civil Rights Board, what type of evidence is going to be required to be submitted either by the tenant or the landlord in one of these types of complaints?
That's it'll be decided on a case-by-case basis, depending on the nature of the complaint.
And then we just have a couple more questions that have come in so far tonight. Do we believe that this ordinance will have any impact on rental prices over the next 5 to 10 years?
Yeah, again, this is a discrimination ordinance. I think Clyde answered that pretty well. You know, this doesn't regulate the market. It's pretty hard to tell what an ordinance could do to market conditions.
Okay. Just going back, just a general question of were local housing providers given an input into this ordinance?
Absolutely. In the last 2 forums that staff held, they were both emails, and reminders went out to everyone that's on our rental registration list. And those 2 forums were specifically held just for those housing providers.
I can also chime in too, just to reiterate before even getting to this point, the amount of engagement that took place starting, before the Isaac Housing Task Force meeting in October 2018, the Landlord Fair in June of 2019, Housing Matters meeting, June of 2019. There were several meetings for people that provide housing, and more than 1,700 doors were knocked, and continuing to have engagement. It was really important that all parties who have to do with housing are part of this, because there are inequities in housing for people who are looking for housing, as well as people who provide the housing. So it was important to get feedback from people who have 1 to 2 units all the way up to, thousands of units, and everybody in between was valuable in this process, not just one particular set of housing providers.
And August 13th, we are specifically reaching out to housing support organizations and partners as well.
Okay. Another question about reviewing an application based on their income. If landlords are not able to discriminate on the source of funding, what safeguards would be in place for damages that exceed a deposit?
Mm-hmm. And so that is part of that pilot program that we are also looking into in terms of the landlord insurance or additional security deposit. But I will leave it to Attorney Robinson, what would occur now if a landlord were to face damages to an apartment?
That's a good question, and it depends on, number one, what does the rental agreement say? The rental agreement could cap it. That could inform the tenant that they could be subject to a civil claim for the amount of damage that would be in excess of the deposit. So those remedies don't change.
Again, this is a discrimination ordinance.
Anti-discrimination ordinance.
Correct.
Yeah. Non-discrimination ordinance. Right.
Are there specific guidelines to screen tenants contained in the ordinance?
No, there are not specific guidelines, but there are, again, when we talk about that blanket policy idea that, we don't want, there are specific categories in the way that the ordinance is broken out, which talks about how tenants can be screened. If you want to add to that, Attorney Robinson?
Yeah, again, what we're looking for is no different than what is currently being enforced at, for instance, at the state and federal level. The Department of Justice has guidelines on how you should use certain bits of information to make sure that you're not unintentionally discriminating against anybody. The fact of the matter is that it is a sad fact that a lot of people who face incarceration are people of color, are African American. So if you're using past convictions as a bar to rental, you are discriminating because it's got a disparate impact on a group of people. And therefore, you're discriminating on the basis of race if you're going to have a blanket policy that you're not going to consider anybody that's got a conviction or a felony conviction. And that is, that under current federal law, that is discrimination. That is unlawful discrimination on the basis of race. And we're looking, and there is no guidelines that the federal government has issued. It's just a question of, you can't have a blanket policy. You have to consider the individual's nature of their crime, how long ago did they commit it, and what have they demonstrated since they have gotten out of incarceration. My eyes were open to this some years ago when we were talking about banning the box in terms of not permitting employers, including the city of Kalamazoo, to ask that question on an employment application. And there were repeated small businesses that said, actually, I don't mind hiring somebody who's just gotten out of prison or who is on probation, because there's every incentive for them not to return. Those are some of my best workers. They show up on time, they're ready to work because they don't want to go back to prison. And one of the things that will help us as a community, and this alludes to what the Vice Mayor said earlier, is that if somebody has housing and they're given a job, they're going to be successful, and we can reverse the trend of discrimination. That's what this ordinance is about.
Okay. Well, I think Attorney Robinson, you just answered the next question, which was how will this ordinance help felons get housing? So is there anything else that anybody wanted to add to that?
Yes, I'll just add, just to reiterate what Attorney Robinson said, or to clarify that federal guidance in terms of criminal backgrounds and not having blanket policies is something that's been around since April of 2016. So it, again, just reminds all the questions about that, something that's been in place for 4 years. It just kind of reiterates the need for education from all sides. Something that should have not been happening, but has in fact continued to happen.
Another specific question about the ordinance. What are the infraction fees or fines, and are they higher than other communities or consistent?
Attorney Robinson?
I'd
Did
have
you, did you have any feedback from Grand Rapids or Ann Arbor and how we're in line with either of those communities?
I'd have to go back and look at those ordinances to be absolutely sure. In that regard, the whole point here is that prosecution and fines are going to be something of a last resort. And so that is, and I'm trying to find the penalty. Yeah, we do have a fine that's punishable of up to $2,000, and this is a municipal civil infraction, and that would be the upper level, and it would be into the judge's discretion as to what the fine should be. But the cap would be $2,000 plus a cost of prosecution.
Okay. Thank you. And then actually, this next one is the last question that we have, and it's a technical question going back to the specifics of the ordinance. Did the city change the standard financial criteria of housing costs not exceeding 33% of a tenant's gross income? And if so, why? And there's a
No.
reference to paragraph 18A3.
1883.
Subparagraph J.
Yeah, again, the 30% of income has been a standard for affordable housing as a portion of your income being 30%. And we haven't changed any of those standards within this ordinance.
Okay.
All that 18AJ says that a landlord who may not require an individual who receives housing assistance to earn more than what is needed to pay for utilities as a requirement for tenancy.
Mhm.
That is a provision that I believe, I think it appears in the Grand Rapids ordinance.
Mhm.
Just to give a little clarity around that, that is intended for people who receive housing choice vouchers. For example, we have a lot of seniors who are on fixed incomes who receive housing assistance, and their income may be their Social Security or their disability. And traditionally, what has happened is a landlord may say, well, we'll take the voucher, but you have to make 4 times the amount of the rent. Well, that's never going to happen for someone on a fixed income. And that's why that component is in ordinances that have source of income protection, because it's that added benefit. So people can really have that housing choice. So that's the intent behind that.
All right. Well, we've got one more question. I'll let the panelists wrap this up here, but do want to also let people know that we also received some comments in general that we'll be including on the webpage. And the question though here that we want to it's a broad question here. What authority does the city of Kalamazoo have to create new protected classes?
We have the ability as a home rule city, and as long as we do not prohibit what is permitted or permit what is prohibited under law, then we are permitted to act to supplement what already exists. So in essence, we can't say that you can do something that's prohibited at state law, nor can we prohibit something that you're permitted to do at state law, but we may provide additional protected classes that supplement the Michigan Civil Rights Act and federal Fair Housing Acts.
So Attorney Robinson, that is specifically the Home Rule City Act, correct?
Well, that's the interpretation of the extent of what a municipality may do. It's not really grounded in the Home Rule City Act. That's what the city gets its powers from, but it's a general principle of municipal law that a municipality, at least in Michigan, is what it can and can't do.
Okay. Those were the questions that we had for tonight. We will be summarizing them also on the webpage that Director Kick pointed out at kalamazooCity.org/chapter 18. And Mayor Anderson.
Thank you very much, Deputy City Manager Chamberlain. I don't think that's an easy job to take questions and try to maybe pair some questions together that might be similar. So thank you for your work on that. And also, I do want to thank everyone who took time to listen and to provide questions tonight. That means a lot. That all said, are there any concluding remarks that need to be made this evening?
I probably just want to remind everyone that, again, we are going to be working to get these drafts completed, and that staff will be making a much shorter presentation on Monday, August 17th, for the first reading at the City Commission meeting.
Thank you, Director Kick. Commissioner Urban?
Yeah, I just wanted to add that all the questions, I think, taken as a whole, really did fill in a lot of gaps in people's understanding of questions were asked that maybe people were happy to hear the answers of, but they may not have thought of them themselves. So a good job with all those questions. But the stress was on, well, what if I end up with a bad tenant? And a lot of talk was kind of on the negative side of this thing. What if it goes wrong? Well, I'd like to remind everybody that there's a lot that could go right with this ordinance too. I mean, if somebody's been discriminated against for who knows how long, for something that happened long ago, and now all of a sudden you can actually find a place to live in the city, that's a good thing. So, you know, there's good that's going to come of this thing, from this thing as well. And it's a work in progress. It has a review period to it. And so we're going to be learning and adjusting as we go along here. And we'll all know more as time passes, and we can make improvements.
Anyone else at this point? So just to reiterate here, what is occurring on the 13th, and when is that occurring, and how do you access that?
So the 13th forum is our last invite only forum.
Okay.
So that is just for the housing providers and support partners that we have that will help us think about the implementation of this ordinance. And so what we'll be doing is, again, putting together that comprehensive report and feedback for you, Mayor and Vice Mayor and Commissioners, to be able to report back to you on Monday. Because, you know, for us, it's all about implementation and how is this going to, how are we going to be able to follow through? And that's why it was really critical when Vice Mayor Griffin was talking about those partnerships. Again, there's one thing the city can do. The city can set up the framework. And then we've really got to rely on our organizations and our support partners to really wrap around us and wrap around that vulnerable housing population that we have. Again, it's fantastic that we have a fair housing center in our own city that can help us and provide those trainings. Again, it's going to take all of us to make this work.
Thank you, Director Kick. And Attorney Robinson, just a question for you. When do you imagine that, and what would be, I would consider the ordinance as it's going to be presented to the City Commission on Monday, when will that be available for people to see, and how will they be able to access that?
Well, the current drafts are on the website that you gave earlier. I don't anticipate there being very much in the way of changes. There may be a few, but I think they will be minor. It is hoped that when the City Commission's agenda is made publicly available later this week, that people will be able to access it. We may even be able to get it on our web page sooner, but again, I don't control that. But I'm going to start working on making those small adjustments tomorrow, and hopefully, given I think the relative few number that are involved, that I hope to be able to complete it by tomorrow afternoon.
Thank you, Attorney Robinson. Deputy City Manager Chamberlain, can you just remind us how that one can access the agendas and that kind of information for the City Commission?
Sure. The easiest way to access those is to go to the city's webpage, which is kalamazooCity.org, all one word, kalamazooCity.org. And if you either search for or scroll to the bottom of the page and click on City Commission, and that will take you directly to the City Commission's page. And on there, you can find the upcoming agendas as well as past minutes and past agendas. But usually usually the packet for the upcoming Monday is usually published by Friday evening prior to that Monday.
Thank you, Mr. Chamberlain. Anything else for the good of the order this evening? So once again, I want to thank everybody for participating. I want to thank all staff and Vice Mayor and Commissioner also for participating in this. It's important that we continue to do that. So thank you so much to everybody. Keep your hearts open, and this town hall is adjourned. Thank you.